On tonight on AIB, we are simulcasting with Rebecca and with Sue Rhoades, and we're going to get into the adventures in sovereignty and some other information. We're going to talk about this DC case that we're involved in, and we're going to bring this stuff up because there's a lot of significant things here that has transpired out of this. Rebecca and Sue and her entourage of people have been following this case. And the information that they have pulled out of this case of the corruption, of how and when this stuff was all being done, has all been documented. So I'm going to let Rebecca bring some of this stuff up, and we're going to get into this. So Rebecca, go right ahead.
Yes. Hello, everybody. It's so good to hear Harvey's voice and everybody out there. We've kind of missed being on the shows and being a part of this for a while. So it's just real glad to have a chance to say hello. And I'm going to bring my partner in crime, Sue Rhoades, on and let her say hello. And then we'll get into what we're doing as far as the DC case and what's going on with this appeal. So, Sue, hop in here. Uh-oh, you're on mute.
Oh, sorry about that. Yes.
There you are.
Thanks. We've got a lot going on. We're working on with other groups and other projects, and we'll bring that up later. But we wanted to put a focus on the DC gun case because we've been following it for so long, and it really makes such good points. We've also been brought, had the Texas cases brought to our attention, which will also do some information, some write-ups on, and maybe a show on. They're also exposing the system. So this is all about exposing the system. This is all about people that are just learning so much and able to actually go in and have these people tell them, no, we don't have any authority. No, we can't answer your questions about the Constitution because we're a corporation. And Rod, of course, has been out there doing it for quite some time. So we wanted to join with him and get an update and share what we know. And take it away, Rod. Go for it.
Ladies and gentlemen, first off, what we need to get into is what has transpired here in the last several weeks. The DC Court of Appeals has appointed three private lawyers to work with the judges. They don't represent me. They're not in here to represent me. They are in here in a capacity as a third-party intervener to sit down and go through my paperwork that has been filed into the court that has been sealed from the public, for them to go through and tell the judges what actually is going on. And this is rare because they hired three lawyers, not one, three. And I'm not going to give their names out right at the moment because I don't want to jeopardize anything. But the point being of it is that one of the gentlemen was noted for in his background of impeaching a federal judge before the Judiciary Committee. This is something that we was teaching back in 2005, how to do an impeachment. This guy was actually able to walk him in and get a judge removed on an impeachment. The other party in this is part of the, what you call professional responsibility board. And the work that this party has done is sort of amazing. And the other gentleman that is a part of this is a gentleman that came out of North Carolina, graduated in 2011, did a lot of law reviews on the corruption of the municipalities. Now, this is what they handed me. For somebody to go back into my paperwork and to tear it apart and redefine it for the judges on this thing, because we pretty much exposed quite a bit on their procedural violations. And this is very significant because pursuant to their procedural way this thing was supposed to have worked, whenever I was up in front of Judge Roberts back on February 9th, I had in my possession at that time, and I don't leave home without one whenever we are dealing with a court, is I had a notice of appeal, stay of judgment. I always walk into a court, and this is some of the stuff that we are teaching people. When you're walking into a court hearing, walk in here with a notice of appeal, stay of judgment. This is your get out of jail free card. That when that judge bangs the gavel, you've got a notice of appeal to appeal their decision right off the bat. So this is an edge on our side of the fence. Well, pursuant to their rules, under Rule 4 and several other rules that's in this documentation that we have filed into them, is within 14 days of your sentencing, you had to have a notice of appeal in within 14 days. I did it the same day. You then have 30 days to answer and put a brief in of what your issues are as the plaintiff into this thing. Within the next 30 days, the prosecution or the United States Attorney's Office had to respond to my brief, and they failed to respond. So throughout this time period from February, March, April was their time frame, we went back in. We filed a notice of fault of non-compliance. Here's your rules. You're supposed to file, and this was all sent out to Harvey. It was in one of the big lists that has went out here back in March, April, May, June area. Then I filed a second notice of non-compliance with them, and they still have not responded. Then I sit down and I worked on a mandamus and a certiorari. Harvey, is that correct? Certiorari?
Yeah, it's called a certiorari.
Certiorari.
It's a weird word. That must be Latin. Certiorari.
Mm-hmm. Mm-hmm.
So when we filed this in, I filed this privately into the Chief Judge's chamber. Within 2 weeks, I went back in and I changed it to just cause for it to be overturned. Well, within about a week and a half after they received this, I got these 3 orders in the mail telling me that, Mr. Klaas, you cannot ask this single judge to make a decision. Well, that is not what I did with that certiorari and that mandamus. That was to order the chief judge to go down to his lower judges and say, hey, what are you doing on this man's case? Why are you dragging your feet? Why is this man filling defaults in and we're not being responded here to him? That was the first one, is that to notify me that this judge couldn't do anything. Well, that paperwork did exactly what it was supposed to, because he took it down to the next level and says, hey, you guys better do something with this. Well, the 2 orders that came out of this was for amicus curiae, and that was for them to hire these 3 attorneys to come out and to investigate my case, because the court found it quite interesting of what I laid out before them. Well, the third order was a scheduling hearing for November 24th. That's when our briefs had to be put in, and an appendix. This is something that we need to get into, and we're going to get into this a little bit here tonight on this. But I wanted to bring you up to date to what we are doing. While I got that amicus curiae and I got that scheduling order, I went back in to amicus curiae under Rule 37, found out what their job is, how they're supposed to be operating, and according to their rules, not mine, their rules, they wrote them, is whenever I filed my brief in, the first brief, they were supposed to file a brief at that time period back in March. They haven't done it. Therefore, they breached the whole contract of this thing. But this is what we brought up. But I also went back and reminded them is that if you are bringing in 3 attorneys because you're deeming me to be incompetent or not prepared,
Yes.
I want to remind you that the D.C. court has already sent me down to a psychologist, and I passed it with flying colors, and I was deemed more than competent enough to handle my own D.C. case. Why would I need 3 attorneys to handle my appeal when I could handle my own case in D.C. and beat them? And I went back and I brought this thing up on the private attorney general side on how the private attorney general was recognized by the Supreme Court through Supreme Court case law, how the private attorney general is recognized by 3 law schools, 2 in California, 1 in Santa Monica, up here in, I think, Michigan. And the fact that Congress gave us the authority, and that's the kicker here. Congress put it as a legislative mandate that we are, and we're allowed. That's the kicker on this thing, is that Congress sit down and says we can. So I went in and laid out the fact that no attorney can walk into the courtroom on our behalf because the Bar Association under Title 36, under Chapter 705, clearly goes back in, defines the Federal Bar Association as a corporation. And it explains under 705.02 that as attorneys, they can only represent the United States government. There's nothing in there for us, but they can represent us. Now it says that they can represent the property, which brings up a very interesting issue. If they represent the property,
yeah,
property of the United States government. That's why they hand me an attorney. So these are the things that we're bringing up is coming back in and exposing that you can't hand us an attorney unless you declare that we're property. If we're property, then you have to bring in our alien custodian, guardian, under the Trading with the Enemy Act, to ask him why he's not doing his job and why he allowed us to go out and do what we're doing, because he is our custodian. Just like you as parents are custodian over your children at 3, 4, and 5, they can't be held accountable, but mom and dad can. And this is what we're getting into with this corporation side. Now, the other side of this fence is that we got into procedural violations under their own rules that they cannot reschedule this thing. Give me a new schedule hearing because their prosecution missed the deadline. This is not a do-over or, hey, okay, we got a dry run here. We know what you're going to do. Now, allow us to come back in and do it all over a second time so we can try to answer you. See how we fumbled the ball the first time. Well, ladies and gentlemen, they fumbled the ball, and they still fumbled the ball.
Yeah, and the biggest thing they did in this, Rod, is that they sent through that one transcript as if that was all they were going to base their case on. They sent that through to this amicus curiae group with that Kessler transcript that really put you in a very good light because it only had one little paragraph where that prosecuting attorney stood mute. But then that's what's been the most interesting thing to me as you got in touch with with this amicus curiae lawyer and said, now, how come you were just given this much of the transcript? Don't you know this has been before 5 judges and 2 different courts and at least 3 or 4 prosecutors and public defenders? That's when it started really getting interesting to me because the judges were trying to skew this case by just giving them limited material to work from.
Well, this is the whole thing. They sit down and they limited them. But see, because I got my hands on the transcript from the grand jury, these amicus curiae never had the transcripts from the grand jury, where the grand jury on the second trial, the second, not the first, second, where the police officer went in and talked to the grand jury and the issue come up. Did Mr. Claus have a carry concealed permit? Yes, he did. So he thought he was able to carry in D.C. with an out-of-state permit. Yes, he did. Now, the issue is that he had a Taurus 44 Magnum. Is this considered a sawed-off rifle? And they said, yes, it was. Ladies and gentlemen, that Taurus 44 is manufactured as a pistol. I checked it because in order for me to have bought it at the time, if it was a firearm by legal definition, that I could have not have bought it unless I had a license and a shows where I pay taxes on buying a sawed-off rifle or shotgun. Therefore, it was considered a pistol. So the grand jury was misled, but even more than that, the last remark was, so this is a tax issue.
One of the jurors asked for clarification on that. And then the prosecuting attorney again lied through his teeth and totally misled the grand jury. And it's all right there in that transcript. Yes, turned it into a tax situation so that both the prosecutor and the witness from the police lied to the grand jury in this particular situation. And it's there, as plain as it can be.
Yes, it is. And so what came out of this, now we're up here to the date where I had to do another brief because they sealed my brief and would not do anything with my brief. So because I had to do a brief and an appendix, I needed a little more information on what an appendix was. I didn't write up an appendix. What is involved in an appendix? So by going back in and doing the research of the local rules for DC Circuit Court, and that's how I came across the two books. I punched in local rules for District of Columbia Circuit Court for appendix. And I found these two books that are not listed on the website.
And somebody had given you a clue that there was some other local rule that was hidden from everybody. Because I remember you talking about that early on, that you knew that there was something else coming up on that. Do you remember that? Yeah. We had some suspicion. We had some suspicion that there was another set of rules, and you found them.
Yep, we found another set of rules. And ladies and gentlemen, this is why this is so significant of us coming back in and fighting them on their own rules and regulations. And you have to look up their local rules because they're not always on their website. But getting into this and reading it verified that whenever I was sentenced on February 9th, I had 14 days to get a brief in. So I now have the rule book that was on the website. I got the two rule books that we found that were internal books, strictly internal. And I had sent them out to Harvard to get posted. But in these three books, it said here and said, the moment I was before Judge Roberts, I had 14 days. Once I filed that brief, I had 30 days. Once I filed that brief, the prosecutor had 30 days. The amicus and curiae had to file at the same time I did. Did they? Absolutely not. So we got 3 strikes. We got 3 rule books that lays out their rules. We got 3 strikes on these people. But what we also turned around and found out is that when we do our briefs, we have to do it in 14 point. You know how you normally have Roman 12. We normally do stuff in. Well, this is 14 point, so it's bigger print. But we had to put this in a binder, a spiral binder with a blue cover on it for the appeals court. This is how it is to be sent in. If we don't send it in this way, this gives them justification to kick out your paperwork for failure to prosecute because you did not send a brief in properly. Now, one of the things that helped me on what we're doing is that we filed informa pauperis. Now, because I filed informa pauperis, I was cut down on the number of files I had to send in. Because I was asked and this is where some of you people are making your mistakes when you fill out this informal pauperous paperwork. Do you own your home? And a lot of people, well, yeah, or I'm renting, or I'm making payments. That's the wrong answer. The answer is no, I do not. The county owns it. Do you own your car? Well, yeah, I got 2-3 vehicles. No, wrong answer. You don't own your vehicles. The state owns them, because all you have to do is go out, look at the registration, and see what license plate on it, and it says for that state. So you don't own your vehicles. This is part of the informal pauperous side of this thing. Do you have an income? No, sir, I don't have any income. Do you pay your bills? No, sir, I pay IOUs.
Yeah.
So when you start understanding the bankruptcy, and you're filing your informal pauperous, you aren't claiming anything. You're coming back in and showing where the state owns everything under the bankruptcy. And you can't pay any bills because the Federal Reserve note is not money. It is a mere promise to pay you someday. And the courts will accept this. This is how we're coming in. So if I would have made the statement, well, yeah, I own my home, and I own 3-4 vehicles, and I'm paying an electric bill, and I'm paying a water bill, you're no longer informal pauperous, because now you're claiming that you got property. Now the number of folders has now went up from doing 4, 3 for the judges, 1 for the clerk, up to you're now doing about 21 of them, because you got to give them to each judge on the appeal session. Plus, you got to do your prosecutor. And in my case, I had 3 attorneys, and all I had to do was just send 1 out to them. So I've sent out 6 documents. So I've sent out. That beats kicking out 22 or 23 at your cost of having them bound and having them printed. Ladies and gentlemen, this is part of what we're getting into.
Yeah, now wait a minute, Rod. Let me understand what you're saying there. You're saying that according to the regulations, you had to, if you hadn't filed the informal pauperous, you would have had to send to each one of those 17 judges on that appeals court the bound copies in all of the binders and everything. Is that what you're saying?
That's exactly what I'm saying. That's what the rules say. If you are not
okay. Okay. All right.
This is where understanding comes in. Ladies and gentlemen, what we are doing in this DC case is that we are throwing up the intent of the law compared to what they have. This really comes down to what is known as an abatement, and to an issue in a court where you are now abating them on their laws, because you're sitting now saying, okay, Congress wrote this. This is the intent. This is how it's wrote out. Now, the problem we have here is that your publishing company, your Westlaw Publishing Company, changed the verbiage of the intent of how Congress wrote it out to what it is in the statutes on the United States Code or the CFRs to a certain extent, especially the United States Code. They changed the intent. So now you've got an abatement, because when you can walk in and say, okay, this is legislation definition. This is how it is defined. Your book company that wrote your books misrepresented the law. Now we got an abatement. Now we got an issue here before the court. How are they going to get around this? This is part of what we're walking into, ladies and gentlemen.
And Rod, with the whole situation that you had here, with the definition of a firearm, I've just been reading that Texas case on the IRS situation this John Trowbridge filed, and he did such a good job of arguing the case of the definition. If you've got a definition that is so clear, like you are dealing with in this particular case with the definition of a firearm, And that definition, if it is by special election, if there are, if it is very, very clear what that definition is, then all of those people who lied about that definition before the grand jury, they are all absolutely culpable in this because they knew that they had to be true to the definition of what that statutory explanation of a firearm was. Now, you brought that out so clearly in that case that there's no way that they can argue around that. And this Trowbridge guy in his paperwork did such an excellent job of showing how, when a definition is that clear, that the court has no choice but to act on that definition. So that alone, just bringing that up, and this is why we kept saying that this case is such a simple one to understand, that we can go in and show the deliberate fraud of the prosecutors, the collusion of the judges, the collusion of the public defender, and how they did everything in their power to actually put you in jail there and doing it deliberate, because there's no way they can get around some of this fraud that they pulled in this courtroom. There's just no way around it.
Well, no, there isn't. And this is part of the problem that we're walking into, ladies and gentlemen. And a lot of people out here that is listening to the calls, I've got a lot of emails. Rod, why did you not just stay on the Second Amendment issue? Why did you bring in with the Enemy Act? Why did you bring in the bankruptcy? Why did you bring in that these people are under the International Organization Immunities Act as foreign agents to the UN? Why did you come in and make the issue of the word person? Ladies and gentlemen, this is what this is all about. These people don't have jurisdiction.
Yes.
They don't have, because they gave it up. And this is one of the things that we brought up in their criminal rules of procedure. Show me in your rule. Here's your rule. Show me where you have jurisdiction. Under criminal, you don't, because it was never given to the court. You're bringing me in under Title 50 as an alien enemy into this thing. If I am an alien enemy, then that makes you an alien to me, and you don't have jurisdiction in our country. This is what this whole case was about, ladies and gentlemen. It was about verbiage. This was a battle of words.
Battle of words. Yep.
It was a battle of definitions. What does this definition mean? What does is mean? Does
yeah.
What does is mean? Well, we're coming back in. What does the word firearm mean? Well, according to your legal definition, the word firearm means a sawed-off shotgun of a barrel of 18 inches or less, or a rifle, 16, fully automatic machine gun, and a silencer. Well, where can you find all this stuff? Well, National Firearms Act of 1934, 1968 Gun Control Act, which is another legislative act, the Firearms Owner Protection Act of 1999. Then we get into the IRS side, because all of this is now a tax issue. Well, what is the tax based on? Well, it's based on a sawed-off shotgun of less than 18 inches, or a sawed-off rifle. So now, what's that definition? That's the word firearm. So now we're coming into all these definitions, and the point being of it is, ladies and gentlemen, all I had was a pistol, I had a long rifle, and I had that Taurus, and that Taurus is classified as a pistol by legal definition from the manufacturer, because it was cut down to be that short as a pistol. So everything that we got into in this DC case, ladies and gentlemen, was all about terminology. It was all about language. It was all about their rules and their procedure.
And so this showed, yeah. Now, this showed a deliberate intent to misconstrue the definition of firearm, and so they do not have legal standing to do that according to their own rules and regulations. The way those statutes are written up, they cannot use the generally accepted definition of what we would think of as a firearm in that case and get away with it, because it is such definite, the statute defines it so clearly that they cannot get away with saying to the jury, oh, well, he had firearms, when they knew that you did not. So, just the intent of the misuse of the definitions is a big part of what we're able to show and prove in this case. And it's a simple one, for people who are not familiar with how the courts really operate. It really goes in there and shows the deliberate intent to deceive. And Sue, I interrupted you. What were you going to say?
Oh, that's okay. I was just going to bring in the Miranda part of it.
Yes.
You interview someone for 3 hours or interrogate them, and then you decide, oh, I'm going to read you your rights now and put you under arrest. You can't do that. You can't do that. And this is what they do. And people don't understand how to fight back. And of course, you're not in a position to fight back at that point. But you can come back later like Rod is doing and point out, this is what you did. You can't interrogate me for 3 hours and then put me under arrest. You didn't have any probable cause. But what you did was interrogate me so that you could find some probable cause. That's what you did. And you pointed that out beautifully.
Yeah, and the unlawful search and seizure and everything else. I mean, it's, constitutional due process violations. And you've done such a good job of arguing this in the brief. Now, when everybody gets a copy of it, sit there and read it. Really read and digest what he has put in this brief, because it is if you understand your Constitution, and I know so many people on these calls really pay attention and try to understand the Constitution, then it's going to make the case really, really clear how he has set this out. And so simple. I would hate to see what these amicus curiae people are going to have to say. It's going to be a very, very interesting scenario to see how they come back in and try to have anything before the court, because it's like, what are they going to argue here? That in itself is going to be really, really something else to see.
Well, it is, because from the day one, when we got into the DC course, when I was brought up for Judge Sullivan over in the Superior Court, moment Dworsky sit down and says, Your Honor, Mr. Klaas is a private attorney general and a bounty hunter through Congress. And Sullivan dismissed the case right then and there. Get him out of here. Give him his stuff back. Mr. Klaas, don't come back to D.C. You're not welcome here. Well, then I got down there and they kept my stuff. Then I went up before the second judge, Nolan, of Nash. All right. And the moment Nash started in, I went down and said, excuse me. I started reading off the fact of the Heller case and the McDonald case. And we got into the terminology. And he decided he didn't want to play no more, so he transferred me over to the federal court. Well, when we got to the federal court, we got before Wilkins. And this is where a lot of you people are making your mistakes. You are trying to defend yourself. I never once defended myself. I am pointing out their errors and their screw-ups of their terminology and Supreme Court decisions of how they're not following their own rules. So when I got before Wilkins, and Mr. Wilkins, Judge Wilkins said, well, Mr. Klaas, raise your right hand. You swear to tell the truth, the whole truth, nothing but the truth, so help you God. I said, yeah. He said, now I got a question to ask you. Because he made the issue that if I lied upon taking an oath, that's perjury. And that perjury is contempt of court. I said, okay, now wait a minute. I said, let's back up here. So you're telling me if I swear an oath and if I lie on that oath, that's perjury and that's contempt. He says, yes. I said, good. Let's talk about your prosecutor. And I proceeded to rip his prosecutor apart because he took an oath to the bar that he would not mislead, misrepresent, misconstrue, put false information before the court. And that's when Judge Wilkins shut the court down. Ladies and gentlemen, this is what we're coming in, what we're talking about. When the moment they leave a door open, you grab the door and you swing it open even wider and you start hammering these people. That's the same thing with Kessler. When we got into the fact of the rules, well, Mr. Klaus, we don't know the rules that well, and I walked back in, had the rule books, and we proceeded to explain the rules to her. And we brought up about Title 28, 2255, habeas corpus, because we also brought up the fact that who is the injured party? Who is the corpus delicti in this case?
A statute.
Yeah,
A statute.
a statute.
Yeah.
An unconstitutional statute.
Yes.
3 times unconstitutional.
Yes.
That's
And
what was injured.
that's what was injured, an unconstitutional statute. But I laid hammer on the prosecutor because I proceeded to explain what he did wrong to her. And again, she yelled recess and set it for another status hearing. So this whole court case, these 3 amicus curiae judges, like Rebecca said, they only got 1 transcript.
And that was the transcript that you're talking about right here. And there were 2 things about that transcript that really hit me. Number one was the fact that you insisted that the rules be put in the court case, so much so that Judge Kessler came back and said, oh, no, you don't have to give me the rules, but I will say on the record that the rules are included. And she listed all of those, including the Constitution, right there in the court transcript, so that we've got that on the record at the same time. And then the second thing that was the most interesting of all to me was that I think it was Lawless, the prosecutor at that particular time, he just practically stood mute when she asked him to come in and say something about the Miranda ruling. Then he immediately just said, well, he really didn't have anything to say. And then the only thing that he did say was, well, Mr. Class brought in all this stuff that had something to do with the civil statutes that didn't have anything to do with the criminal statutes. And that was literally the only paragraph that he said. And so I'm looking at that and saying, okay, people who understand the Constitution and the constitutional authority, the jurisdiction of the courts, ought to pick up on that statement that he said, because that in itself was a fraudulent statement. So it's like, as you begin to read over all of these cases, I'm finding that as I read more and more cases and understand it, my level of understanding, comprehension of all this stuff has just skyrocketed the more we do this. So it's important that you do read all of this information so you just learn so much from it. I really got tickled today because I was spending time reading that Texas case, and I realized that I read case law like other people read good mystery novels. I'm finding these bones just lying around all over the place now. And just get a kick out of it because you learn so much when you get in there and decipher all of this like Rod's talking about. You got to learn to read their paperwork. And it can be quite entertaining as you get in there, determined to learn how you're going to hold them accountable.
Well, that's it. And that's what I have done throughout this whole entire case. And on the administrative side of everything that we've done, we've come back and hammered them with their own procedures, their own rules. Because, see, the problem of it is with this appeal is the prosecutor was told not to put anything in memorandum and law into this court case. Well, the problem of it is all the documents that I put in according to the rules, and I filed my briefs in, I filed my documentation, says, excuse me, he hasn't answered my paperwork. He only had 14 days. He has defaulted. I want a case dismissed. we went back and showed in the federal district court, he didn't answer any of the paperwork. He didn't answer any of the paperwork in the appeal. And what I think what's got them rattled more than anything is that we brought in the Miller case of 1939 into this court case, showing where Miller won his appeal in this appeals court, but because he did not go to the Supreme Court, the United States government did, and they got their ruling based on a one-sided argument. Well, that was one of the issues that I put into this appeals court. Excuse me, here's the Miller case. Did you guys forget to tell the people that this was a one-sided argument? Is that Miller won his appeal on the appeal side, but he failed to go to the Supreme Court, and therefore the Supreme Court could only rule on what the Supreme Court did for the government side? Ladies and gentlemen, now we got a problem here because now I'm before the appeals court. Miller hasn't, the United States government hasn't answered. Like the Miller case, if he hasn't answered, they've defaulted. So you can only rule on mine. And this was part of that amicus curiae that we put in that mandamus. And I think this rattled their cage because, see, I was never supposed to know how Miller lost his gun case was through deception, through fraud, and through a default because his attorney never showed up. And that's
yeah. So this is how you think they're trying to get around some of this clear statute regulation on firearm, that they've misconstrued definitions there in some way because of that court case?
That's exactly what they did, because it was the Miller case that really set down the word firearm. But see, the Supreme Court never used the word sawed off. It used short barrel. Now, if you can go out and buy a hunting rifle that's got a full-length barrel and stock, and you can go out and get one of the pumps that's got a pistol grip. That barrel is much shorter than the hunting. But that's not sawed off. That's a short barrel shotgun. And what they're bringing up is a sawed off. And that's exactly what's brought up in the transcripts. Mr. Class had a sawed off rifle. I didn't have no sawed off rifle. I had a Taurus 44 lever action pistol. It was manufactured that way. And this is how they're coming out and hammering the people. So what is going to come out of this? Because we went back into the Geneva Convention, back into the treaty between the United States and all the countries that sit down and said rifles and pistols and revolvers are considered small arms, not firearms. And because of this definition, because of what we're bringing in for the treaty into this, and we're bringing in their different legislation, their terminology, they are trying to find an avenue here. And they've brought in these three attorneys here. Now, I don't know what they're going to do with them. Can I fire them? Absolutely not, because I've already asked them, with what we put in, they said they don't work for me. They are working strictly for the judges as a third party. They're in here to put up my best defense that they could come up with, to put up the best defense for me on this. But I think after they found out that I've had 5 judges and multitude of status hearings, they now are complaining that they have to pay for the transcripts. That one transcript was not enough. I had transcripts from Sullivan, Nash, Wilkins, from Kessler, and from Roberts.
And you denied those transcripts, weren't you, when you asked for them?
Yes.
Yet these amicus curiae attorneys have not been denied.
No.
Those transcripts.
Nope.
Very interesting. Now, and it appears to me, just from working with lawyers, I see how they work in packs and in herds. And it seems to me that they're just building a new sandbox here to play in.
Yes.
At the same time, some good can come out of it. But this is going to water down the responsibility of the judges, in my opinion, because these attorneys are going to water down the entire issue. They're going to make their points, and they're going to make your points, but they're also going to water it down for the judges and kind of take some of the heat off the judges and probably blame it on the law itself, is what they'll do. The interpretation of the law itself, and that these judges were not really, they really didn't mean to misinterpret what firearm meant. This is why they did, is because of the law, you know? And I have a feeling that that's exactly what they're going to do. We'll have to see, but I can just see it happening. It's going to be funny.
Well, I think with what we've seen in that one transcript, they're pretty much trying to hang the prosecutor in this one for not doing his job right and sort of keeping his mouth shut on this. So it's got to be interesting, ladies and gentlemen. Did I have a choice? No, I did not. Did I turn in a brief? Yes, I had to, because if I did not turn the second brief in, then they was going to dismiss the case for lack of prosecution on my side of the fence, even though there was these 3 attorneys involved. But I did turn in a good brief. Harvey and I worked on it. He's got a poster, getting it posted for you guys to sit back and look at. You've got an opportunity to look out how the appendix is laid out. And one of the key things in the appendix that you have to have in the appendix is, 1, did you file a notice of appeal, stay of judgment? Yes, I did. So I put this in as evidence. I had 3 stamps on it. When it was received, when it went to the judge, and when it finally got back to the clerk of court. I got 3 stamps on it. I was supposed to turn in the memorandum of law of the judge's ruling. Well, according to the docket sheet on 90 and 91, that order is sealed for public viewing, only for bar members only. So that was something else that had to be in there. The other thing that I did put in was the transcripts from the grand jury, the last 3 pages that shows what the decision was based off of. So this is what goes into an appendix. It is what is in the transcripts, if you can get them, find their errors. What was the judge's order and memorandum? But because I couldn't get it, they were sealed. So now we have to put this in that they were sealed, so I could not rebut them. But the most important thing is that you filed your notice of appeal in a timely manner. And you sit back and show it. And I did. I got 3 stamps all the way back to February. And here we are in November. And unless we are in Alaska, where the days are 6 months long, these people are probably about 8 months late on filing paperwork.
Hey, Ray, Rod, point of order. The documents that I've been posting on the TalkShoe little message board there, and the documents that are in the big list that went out today.
Okay.
The appeals doc is only the text version, which does not have all of the last things that you were talking about. So maybe one day you can get a copy of, make a PDF out of all those things that you were talking about.
Okay.
You know, the transcript from the grand jury and the other stuff. So because the document, the appeals document is in text form so that people can use it as a template, but it doesn't include all of the bells and whistles that you just filed into DC.
Okay.
Just so you know. Yeah. And just so the people out there listening to this will know. Because, you know, they'll say, oh, well, wow, I don't see the stuff that's in the appendix.
Okay.
We do have the appendix, you know, indicated, but we don't have the things that are in the appendix that you actually filed.
Okay.
Just so you know, okay?
All right.
But yeah, all that stuff went out today in the big list.
All right.
Okay? All right. Anyway, all right, I'm all done.
But, ladies and gentlemen, this is part of what has to go in the appendix of what we are addressing here. It's the fact that you have to put in the fact that you did file an appeal, what date. You have to have the memorandum of order from the judge. What was his decision? How it was based on? What are you rebutting on it? And anything that you can find in the transcripts that goes back and show errors, that's in your favor. Like I said, because I was not allowed my transcripts, that I couldn't put anything in. But however, I did get my hands on the transcripts for the grand jury. And ladies and gentlemen, that is better than the transcripts from the courtroom, because it shows at the very beginning fraud was on the court, because it started in the grand jury when they lied to the grand jury and deceived them of what was going on. So if the grand jury was told the truth, would there have been an indictment? Absolutely not.
Now this one also, this last grand jury, that had to do with when they went back in and superseded the first case, didn't it? This was the second one that they did? So that this is what resulted in all of the case got superseded, which means it was changed so completely that they came after you basically the third time there.
Hey, Rebecca, can you hear me?
Yes, uh-huh.
Rebecca, this is Harvey. You've been breaking up for the last 2 minutes.
Okay, thanks, Harvey. My signal's not always good. Okay.
I'm hearing you just fine, but
okay.
I don't know what's going on. There's something wrong with your phone, or the connection, or whatever.
Okay, thanks.
you're fine on this end here, just so you know. So I don't know where the issue is.
I don't know. I'm probably breaking up.
Could be. We're all breaking up.
Okay, but the whole point here was that the grand jury was deliberately misled, which led to them picking you up and this whole mess unfolding that led to this plea bargain in the first place. So this is where you're able to show the pure fraud that was perpetrated through the grand jury indictment.
Yeah, we're hearing every other breath.
Okay.
Well, it may be.
I don't know what the heck the problem is here.
Well, we're going through my telephone, Harvey.
I'm sorry, what?
We're going through the telephone. I have you hooked up.
All I'm hearing are is almost gibberish.
Okay.
Yeah. I mean, I don't know what the other people are hearing. You know.
Okay. Well, maybe you can sort of repeat what I was saying, Rod.
I hear you fine, but I got the same problem you do with hearing them.
Yeah, it's like stuttering. Yeah, there's some kind of electronic stuttering going on.
We're on the same phone, so.
Right.
Okay.
So, I mean, I don't know if that helps you guys or not, but
All right.
I don't know if you guys want to hang up and call back in, or I don't know what.
All right. Let me redial back in again, because see, they're not.
You're totally clear. It was Rebecca who was actually just stuttering. You couldn't understand a word she was saying for like 2 or 3 minutes.
Okay. Well, we're trying to go through the internet on her, where she's speaking through the internet here. Let me change the phone position and see if that helps. No, say something, Becky.
Okay. Testing 1, 2. Testing.
Now, Rebecca, I don't know what the heck the problem was, but for the longest time, about 5 minutes ago, up until about a minute and a half ago, it was unintelligible. But
Okay. My signal does that sometimes. It's probably on my end, Rod.
Okay.
So just carry on.
So you may want to repeat what it was you said.
Oh, okay. Well, I was just talking about the superseding indictment that caused so much of this problem there at the end of October, where they picked up Rod again and caused so much of this plea bargain to come down. This is the one where we have the clear proof that the grand jury was lied to and misled deliberately. So it really brings this whole case into absolute dispute and question.
Well, that's what we got it, because supposedly I was supposed to have had a hearing on October 27th. I was supposed to show up on.
Yes.
I filed paperwork in to tell the judge that I would do in camera with him, or we'd do phone. I will talk to him, but I wasn't going to show up in a courtroom. And little did I know that on October 23rd, they dropped all the charges and reinstated brand new charges on the 23rd, 24th, 25th. And I was supposed to have been given a 30-day notice of these new charges. Well, they didn't do that. So they kept this hush-hush on this. And this transcript we got goes back in and shows that I was being charged for non-paying of tax and transporting a firearm across state lines. Well, that was not part of my charge. My charge was I was supposedly had a firearm in the D.C. on federal property. But the moment they sit down and said to the grand jury, well, this was a tax issue, he transported, that blew the whole case because that isn't what I was charged for. So it goes in, like I said, ladies and gentlemen, you have to stay on top of your case. Whatever you are involved in, you have to stay on top of it. And you have to come in and point out every one of their errors and every one of their screw-ups that they're doing. This is why we're talking about getting the PAG classes up through a webinar in order to start teaching the basis of this thing. Now, it's going to take more than a couple days here. And we're talking at least a year, if not longer, to walk you through slowly to start understanding this stuff, because this could get into a real fast pace. And if it does, you're going to get lost. And some of these weekends that I have done, I've done a cram course on some of this stuff. And even though the people got a lot of information, they did not have enough, because you need to learn how to do the paperwork. You need to understand their language. And whenever you get an order from a judge, how are you going to answer this? Because I've had several people that I've talked to over the last several months that says, Rod, I did what you did. Did you? Yeah, I walked in and told the judge that he's violating the rules. I said, did you tell him which one? Well, no. Then you didn't do what I did. Well, Rod, I told him that he violated the statute. Did you tell him which one? Well, no. You're not doing what I did. This is the point, ladies and gentlemen. When I walked in and I got into the hassle with Kessler on this, we brought up the rules of evidence of 402. What is admissible in court? What is already supposed to be here as a foundation? Number one, the Constitution. Number two, the federal statutes. So you can't tell me, well, we don't practice law here. We use theories and concept. I'm sorry, your rules of evidence don't say that. It says federal statutes. It don't say theories and concepts. It says these rules are admissible. It says Supreme Court decisions are admissible. What part of this don't you understand? And this is why I insisted that these rules get put into the evidence file in the court case, so they can't come back and say, well, we didn't understand. Here's the books. Here's the books. That's what I got into with Roberts. Well, Mr. Class, you really can't file paperwork without leave of court. Excuse me, did you bother reading Rule 12? Rule 12 of Criminal Rules Procedure sits there and says I can file paperwork and rebut any accusation made by the prosecution, and you can't turn it down because it may be an appealable issue that I can have an appeal on. You can't throw my paperwork out under Rule 12. So by coming back in, ladies and gentlemen, and being very precise of what you're telling them, it's a difference that, well, your rules say this, and your rule, what rule? Tell me what rule you're talking about. And an issue would come up that if the judge would tell you what rule, and you would gain your freedom. Just it does it. You tell me the rule, and I'll let you loose. What would you do? And how would you handle it?
And Rod,
yeah,
This is one of the things that's so exciting to me. If everybody could see what was going on in the background here, because Steve and his transcription team just handed over about 700 pages of transcripts of the AIB radio shows over the last year, especially since we've been working with all of this information over the last year and a half. And then he has this mind mapped so that as we go through this training and as we finish up the source documents and we really get into the DC gun case, then as we contemplate doing the PAG training, then what we are doing is doing this in step by step by step procedure, so that you're going to have that right there in front of you. If you get just a simple traffic ticket, if you get hauled in on a case where Rod, was handcuffed and put in the slammer, what are you going to do? And it's going to be in such a way that you will have that sheet in front of you and be able to understand it step by step by step, so that you can begin to have this foundation, this information that Rod has put together over a decade. I do not know anybody who can rattle this stuff off the way he can. But by the time we're getting all of this information down so that we can begin to share it with you all in a really, organized step-by-step, fairly simple procedures, because when you read his paperwork, it is simple to understand. It's not complicated. Well, these codes and the things that we're dealing with, when you take it like that step by step and you just begin to follow a system, follow a process toward understanding what's going on, it begins to compute. It's like the light bulb going off, and all of a sudden you have the process so that you can begin to understand the paperwork. You can begin to understand what you need to do. And as we get the foundation for the source documents, that's really coming along beautifully. People are really going to be able to tie exactly how this thing works, so that when somebody says to you, they print money out of thin air, the banks print money out of thin air, you're going to look at them and say, no, they don't. They utilize our signature and then they embezzle and steal it. Because you're going to be able to understand exactly how they do that by following this paper trail that we're laying out through the source documents. That in itself is going to be such a foundational course that will set the stage for what we're doing. And then as we begin to put the PAG training, and then as we're proving what's going on in the courts, just listening to Rod tonight, you see how many errors that have been made in this case, and we'll be able to prove beyond a shadow of a doubt just how deliberate that court and every officer was to try to prosecute Rod because of his knowledge. And if he did not know what he knew, and if he did not stay on top of this, well, he could be one of the ones who spent the rest of their lives in jail because they couldn't handle it. It's not easy to do what all of us are doing. And, I just want to send a shout out. We just got word this month that Irwin Schiff had died while he was in prison. And Irwin is one of those guys who, bless his heart, he did his work down through the years. He was one of the forerunners who did so much of this. And all of our work depends on all of these people who have put the time and the energy into the research and everything that's been done. And so what we're doing behind the scenes is really putting this in a format that we'll be able to share that over the coming times. It's quite a bit of work, but we really are behind the scenes getting it done, aren't we, Sue? It's just exciting what's going on, really.
Well, what we want to create is something that people can go back to and say, this is not a conspiracy. This is a template.
Yes.
This is a template of behavior based on a set of rules, based on a set of acts that were created over a number of years. And you can point to them and say, this is what this created. This is what this created. This is why we're here. So once you understand how we got here, you can certainly understand how we can prevent it ever happening again. And that's really where I'm at with all this stuff.
Yeah, well said.
Yeah, if people understand how we got here, they can certainly understand how to prevent it. And that's what we want. I mean, the kids in school, they don't know anything about these acts. They don't know anything about the Constitution. They're not taught civic responsibility. They're taught volunteerism to the government is what they're taught. So, you know, these documents can become reference materials for people who want to teach their kids, look, this is what really happened. And it's here in black and white. So it's very valuable material as far as I'm concerned in that respect.
Yeah. Yeah, and it's really just, you know, it's a joy to me to see it begin to come together, because it's complex otherwise. You know, if you don't find a way, and I can't wait to share Steve's mind maps. He just does such a good job with this. And when you're able to see what we call the enabling acts, you know, just in this mind map form, and all of it is just in order. Just the mind map alone gives you so much information that you can begin to follow it. And then as we've done a lot of the transcripts, I mean, I've been reading over some of them, been really working on that this week. And some things that were not clear to me, just all of a sudden, just reading over that, oh, now it makes sense. You know, when we do all of our work, when we're on these radio shows, when we do all of this, and we listen and we try to learn, then sometimes just that one clarification makes all of it begin to make sense. And so we'll, you know, I mean, it's a real heavy-duty process that we're working on behind the scenes to finish up all of this work. And just the DC case alone, 2.5 years worth of all of these filings, and reading all of these and the appeals and everything. And now as we're waiting on this amicus curiae brief, because Rod, now the situation that I understand, the amicus curiae folks have to have their brief in by the 24th of November. And then the plaintiff, the United States, has they have until December 25th to get their reply in. And then there is an answer that's due, January, what day in January?
It's back on January 7th.
Okay, January 7th.
January 7th.
So we probably, we won't have a ruling until sometime the first of the year then.
Yeah, thereabouts, because it's going to be interesting, like I said, because these three attorneys, the fact that the court only handed them one transcript, and now they have to hire a transcriptionist to go out and get the rest of them at their expense, because see, they supposedly did this for free. That's what the guy told me. Well, we did this for free because we're coming in here to assist you. Well, they turned around and found the court lied to them. There's more transcripts than they ever thought was going to be coming in on all this. And the point being is, ladies and gentlemen, on all this, and we went through this in Charlotte. I did it here on this last weekend. I had a couple people come in from out of state dealing with traffic issues. Ladies and gentlemen, the rules of criminal procedures and civil procedure are very, very important, because it lays out how they are to bring forth a complaint. Not just you, them.
Yeah. Yes.
And they're not following it. Even under criminal rule of procedure, it sits here and says under rule 3, 4, and 5, especially 4 under criminal rules, in order for them to do a probable cause. Well, I got probable cause that there's drugs in your car. I got probable cause of... Under your rule 4, you had to have, number 1, a complaint. Number 2, an affidavit. Number 3, you either had to have a summons or you had to have a warrant. You can't have probable cause without the first 3. It doesn't sit here and say that you can come out here and arrest me on the street and then come up, write up a trumped up charge on what you did afterwards. You have to have. And the guys that I talked to, it sort of stunned them, but I walked them through. I showed them where it was at. And, you don't argue with the guy out on the street because he'll shoot you in a heartbeat. But you do walk in, and the moment the judge says, I object, Your Honor, we got a problem here with your prosecutor and your police officer over here because they failed to follow procedure under criminal rules, procedure rules 3, 4, and 5 that sits there and said a complaint had to be filed. And we got another issue here is under Rule 26, under the appendix side, under the appeal side of this thing, but even here, you have to disclose your corporate status. What is your corporate status in this courtroom? How are you operating? But ladies and gentlemen, if you don't know any of this and you walk in, they're going to walk all over you. This is why it is significant. Even the very first case I got into in New Philadelphia, the gentleman that taught me, like I said, I had a 6 weeks cram course. The moment I walked in the courtroom, the magistrate, I jumped him. Where's your oath? I want to see your bond. They left. That's the same thing with when I went before Judge Space. Your boy and your girl over here don't have an oath. They don't have a bond. They don't have a case. You know, my first experience in this, I walked in, learned how to hammer them right off the bat. I didn't come in here and defend myself. I didn't know how, but I do know how to attack them. I do know how to break and show their procedural violations, their rule violations, how they're not doing their job right. This is the issue. Before you can commit a felony against me, before you can drag me in here, you're committing a felony against me. You can't drag me in if you're committing a felony. That's the issue here. This is what has rattled their cages in D.C. This is why the prosecution could not rebut anything. And this is how you want to hammer them. That's what I did up here in Gastonia. This is what I did here in Lincolnton. I've walked in and I hammered them right off the bat on all this stuff. And this is the significance of this teaching, is to teach you how to come in a proper way. Just don't walk in and say, well, your rules, you got to follow your rules. Well, what rules are you talking about? You're talking about the sports rules? You're talking about basketball rules? Well, your rules. Well, what rules are you talking about? You've got to lay down what it is on what you're saying. You have to define it to them. That's the same thing with what the laws. We have a conflict in law, Your Honor. I can see right now we are going to have an issue here because the intent of the law says one thing. Your interpretation out of your law books, which is written by a publishing company, misconstrued the intent of what Congress said it was. This is what gives you your abatement. Because once you go back and show that there is a discrepancy, that there is a conflict, that conflict now has to be addressed. They don't like to address it. They try to sidestep it. The point being of it is you have to hammer on these people on this. And the fact that this paperwork right now, if you stop and think about it, this paperwork is still in an in-camera hearing. It's all being sealed. It's being printed into a chancery setup. Whether it's chancery, I'm not going to sit down and say it is, but it's being put into a chancery setup because everything is kept private on their side, and what they're doing with my paperwork, they're keeping it private. So it's going to be interesting to see what they come up with and how they come up with it. So you ladies got anything else?
Well, we'll know by the 24th, they have to give you a copy of what they're going to file. But now there is to be, if there is a possibility that there is a hearing, but you won't necessarily be informed or be invited to that hearing from what I'm understanding.
No.
Yeah.
That is the other thing, is that they did grant these people an oral hearing.
Weird. I mean, this whole thing is just so weird to me.
They granted them an oral hearing. And ladies and gentlemen, stop and think here what I have accomplished in the last 2.5 years, to where they were forced to hire an outside law firm to come in to define my paperwork, because it's like Rebecca said, my paperwork's pretty clear, pretty cut and dried. They didn't do this, they didn't do that. That's what they did wrong here. Now, I know that they have to come in and try to lighten this stuff up a little bit so it ain't quite so damning on them. And that may be why they hired 3 attorneys to see if they come up with 3 different opinions on what's going to be a good case law on this. Because we actually changed the definition of the word firearm on these people. We proved it. Now, if they still come back and say that you have to have a permit for a firearm, ladies and gentlemen, that now means that we can bring in a sawed-off shotgun, sawed-off rifle, fully automatic machine guns, and a silencer into D.C. because their gun laws say, now you can have firearms in D.C. They really don't understand what they're saying. But we know what they're saying.
You took them off script.
Yes.
They've been following a template, and it's very clear, even from if you look at the Texas cases too, you'll see that the template that they follow is pretty much the same.
Yeah.
And they've got a cover for everything that you may do. You know, they can protect themselves, except for when you continue to hammer at them. And you don't stop, because you do know what to look for. And that's the key of what it is that you're teaching, is to know what to look for. And the basics are what? Know the rules.
Yeah.
Know their language.
Yep.
And know their job description.
Yep. Them 3.
And those 3 things, once you have those down pat, you can take them off template exactly like Rod's doing.
Yeah. And the persistence.
They don't follow what they put in writing that they want you to follow. And you'll be able to see that. Yeah. And the persistence.
Yeah.
Take that.
And the thing about it is, you know, you go into this, in my particular case, you know, I went into this an absolute neophyte. I can remember the first time I ever got into a courtroom. I can remember that judge, look, it was a simple traffic ticket the first time I did anything, you know. That judge just looked through me as if I wasn't there. And so that taught me a lot just in that very first time. But then as I began working with my brother on this child support enforcement, and I started seeing what kind of games these people played. And, you know, they dismissed the case. They closed the case the first time we filed the UCC-1 and the UCC-3 that made the clerk of court responsible for settling that case. And then we watched the sheriff and the assistant district attorney come back in and try to use the driver's license as a way to recontract, even though we sent all the notices ahead of time. So you have to watch. I mean, and you're going to learn. Anytime you get caught in a situation like this, you're going to watch the games that they play, and you're going to learn sometimes after the fact as you go back through and start going through all of this. But if you persist, you are going to have a way to start understanding what we need to do to hold them accountable. And that is, you know, that's really what we've got to do, because there is nobody else who's going to do it. It's up to us. And I think that's the thing that people don't always understand, you know. How else are we going to change this if we don't pay attention ourselves and you know, take responsibility? That's the bottom line.
Well, I got an email, and to a certain extent, the guy's right. We do not have a college degree for law. It's not our job to go to law school to learn law.
No.
But why do we have to comply with the rules on this brief that it has to be 14 point, no more than 40 pages for the brief and whatever the appendix is? Why do we have to put it in a blue cover with a spiral around it? That's not our job to do it. Ladies and gentlemen, this right here is how they hammer us, because we don't go back in and we don't follow the rules. Granted, it's their rules, but right now we're in their sandbox. It's like when you come to my house, you come to my house, you respect my house. You don't come in here and with muddy shoes and do whatever you want to do and just throw your muddy shoes up on the. That ain't how that works here. I don't come into your house. And that's what we're coming into, Rod, is that we are walking into their house at this time. Now, you can sit back and say it is our house, and technically, yes, it is. But the bottom line is, if you don't follow the rules that they've laid out and go back in and hammer them on their rules that they laid out, this is why we are getting hammered. This is where the difference is. And I'm trying to show you people by coming in and bending a little bit and working with this. Because, ladies and gentlemen, we got big fish to fry out here. Because part of what we're getting into is administrative procedure. As now, once we start running administratively on them, now we can come back in and say, excuse me, show me where I was required to have a legal degree. Show me where I am required to have followed the rules that you've laid out in your books, especially whenever you hid the books. That's the key thing here. You hid the books. You didn't have them on your website. You didn't have them in open where we could just sit down and come across it. Oh, right there. You had them hid. Why did you hide them? This is what this is coming down into, ladies and gentlemen, is the administrative side. But in order to prove the corruption on their side of the fence, you have to go through the pace. That's what I'm doing. Because right now, I'm the best one out here to go through the pace with these people on what we're doing. And not that I deliberately set this thing up. It's just the fact that I just have to drag my ass into this thing. But we're weighing this stuff out. And what we're trying to teach you is on the administrative side. Before they knock on your door, let's go knock on theirs. And they're going to come back and say, well, you don't have a claim here. Well, excuse me, because a legislator here in North Carolina just tried to pass a bill, was trying to get a bill passed for a new administrative court. And the issue is that this is for public officials only. No, you're right. That's exactly what it is. It's a public official court. That's what an administrative court is. And the one gentleman sit there and talked to Art and sit here and said, well, you don't have a claim here. Yes, I do. The fact that these guys are out on the street not doing their job right is my claim. The fact that they're not following procedure is my claim. The fact that they did not do nothing to me at this time is not the issue. These people are being paid in good faith to do their job right. And because they're not doing their job right, that gives you and I a right to bring a claim against them and lay charges against them and do the 14th Amendment bounty on them. Once we get a conviction that they don't work here anymore, the lights are on, but no one's here. This is what this is about. It is about administrative, but you have to go through the proper process. And this is one of the things that we were teaching. If you are going after the local law enforcement, you have to go after the mayor, notify him. You have to notify city council, the city law director. You have to notify the governor and the attorney general and risk management if you got risk management in the area. Because what this police officer did, you got to notify these people first. This is your first administrative step for them to cure the problem or sit down and say, he don't work here. Thank you very much. Now you take them to the administrative court. That's the same thing with the county level, same thing with the state level, same thing with the Fed. This is what we're doing here. We are coming in and we are exposing the fact that they got rules here and they are not out in the open. It is not in their standard rule book on their website. It's hidden. The fact that I found it is the issue here, that how I was able to follow the rules to keep my paperwork from being thrown out at this point.
And if you hadn't done that, if you hadn't gone through that process, you would not be able to expose it for what it is now.
Yeah.
And to help so many other people understand that this is what they do. So
Exactly.
when people say, well, I'm too good to go to a court, I'm not going to go to a court. It's not my court. It's their place and all that. Why are you bowing to them? You're not bowing to them. You're actually setting out little roach motels. That's the way I like to look at it. And little rat traps, basically. And sooner or later, they're all going to go in there. And now it may take some time. And like Rob was explaining, it takes time. He's gone through a lot of crap, you know, and been thrown in jail and the whole bit. But in order to expose it to the level that he has, this is what people have to do. And if you're not willing to do that, that's fine. But listen to people who are willing to do it, to see what they do and how they can teach you exactly how the system works from their experience.
And then just wait, as Steve has mind mapped this step by step, so that what Rod just put out, you know, just in that big mouthful that he just got down, as we're putting step 1, step 2, step 3, step 4, and then he's got these little notes that go over and give you the statute and show. It's just so much more understandable that we can follow this. So this is what we're all doing behind the scenes, you know, because Rod has put the time into getting the procedures down so that we can begin to understand it. Just like Dwight did such a good job of figuring out the SF95s and teaching us and helping us figure all of this out. Well, as we get all of this material down so that we can begin to understand it, what a third-party intervener does, you know, how we can help in whoever situation, foreclosures, whatever we're dealing with here, then we can begin to put it together in a format that more of us can make it easy enough to understand that we can follow it. And that's really what we're doing behind the scenes here. So we're excited because, you know, it's a lot of work, but it's really coming together as we've had a chance.
Yes, yeah, exactly. And you do not need a law degree to do this.
No, absolutely not.
You don't need to have, 4 years of college to understand what they're doing. They've created that paradigm. They've created that situation.
Yeah.
It's been their sandbox. We've allowed that to happen. Yes, unknowingly, but we have. So now we need to fix that. So we just turn the tables and make it our sandbox and point out to them, this was our sandbox to begin with, and you took it away, and this is how you did it.
Yep.
Well, see, that's the whole thing with what we're talking about here is laying this stuff out. You know, I've talked to so many different people, and their attitude is, I'm going to walk in, I'm going to keep my mouth shut. I'm not going to. Well, the moment you don't say a word, then you are giving consent to what these people are doing. And then if you get your head handed to you, then don't sit here and complain because you kept your mouth shut. The whole purpose of this is to teach you how to fight back and how to come back and use your rules and regulations against them, because after all, they created these rules. It's like I pointed out to Kessler. The United States Code does not apply to you and I. It never did. It never was passed in 1925 by both houses. Congress may have passed it, but the Senate never did. And whenever we got into the 1935 Federal Registry and the Industrial Recovery Act, where Congress gave the President and the Administrative Commission to codify the statutes at large for administrative purposes only, then how can you turn around and bring a USC claim against me when it doesn't apply? Because number one, you never passed it. And according to your book, and this is what I had in my hot little mitt when I walked in there with her, I said, you want to see the proof that Congress never passed it? It wasn't passed by both houses, and it's only prima facie law, so how can you sit here and bring a claim? And like I said, when she asked the prosecutor, he just dropped his head, couldn't say squat. He could not rebut it. These are the things, ladies and gentlemen, of what we're getting into. This is what we're trying to teach. This is what this webinar is going to be about. It's about slowly educating you to where you could comfortably walk into this thing and go head to head. But the main thing here is not so much of you going out getting a ticket in order to test the theory. It's is that we want to bring a claim against them to test the theory. Bring one against them, and then go back and argue it.
You know, the system's designed to put you on the defense.
Yeah.
It's intimidating. It's red tape. It's, you have to have a license for this. You have to do this. You have to, and then there's silly rules you were just pointing out. It's designed to put you on the defense. Knowledge will put you on the other side of that, the other side of that equation, and empower you. So,
Yes.
and that's what this is all about. It's just gaining that knowledge to empower yourself to walk in and say, and know who you are, because it's a truth. You're way above them. So with this knowledge, you'll be able to come in with that attitude, instead of saying, well, I'm too good for that court. You know, well, we can all say that, but you don't even need to go in there and do that. Go in there and show them that you are, just by knowing their rules, their language, and their job descriptions. That's all.
Yeah. Yeah.
Well, not only that, but it's like I've done here in North Carolina. All right. The moment I got pulled, I filed for an administrative claim. The moment I got my date for my administrative hearing, that court case in the county got dismissed, because that court date went to the administrative, not to the county court. I overruled them. And ladies and gentlemen, that's the key here. Is I talked to too many of you, Rod, I got to be in court tomorrow. Can I file an administrative claim? Absolutely not. You should have did it back here when you got your ticket. You should have did it the moment you got stopped. That's when you start your paperwork. You don't wait till you walk into court, because I'm telling you, I did it, and these county courts dismissed it because the administrative court had jurisdiction, because there's an administrative issue. This is part of what we're trying to teach. It's part of what we're trying to get you educated on, is how to turn around and reverse the tables on this with these people.
And you know, the source documents makes that so clear. This is the thing, you know, as we begin just to lay this out, those people who are really just new into this, or even if you've been studying for a long time, when you can see this in the order, in the way that we have done this with the Lake Norman footage that we got last year, as I've been doing all the transcripts and we're putting all of this together in the form that people can begin to understand it, you're seeing exactly why you go to the administrative and what that means. It's just like, you know, as Paul Bam was working with Rod on this source document video, and by the way, it's really good. But Paul just kept saying, well, the government this and the government that, and Rod would just nail him ever so often and said, that's your problem here, because you're still acting as if it's a government. It's a corporation. You know, he emphasizes this, and then we're able to prove in no uncertain terms exactly where within the congressional records and everything, and you've got it right there so that you can always go back and look at it. You can say, all right, this mind map pinpoints exactly how this was done, and here's the date. And you can go back and you can understand it with such clarity. You're going to know why it's an administrative issue. It's not a government issue. These are administrative agents who are the DCSS and the DMV and all of these people who are coming after us in so many ways. And you're going to begin to understand that in such a way that your thinking shifts. It's just like by the time the end of that interview happened with Paul, his thinking had shifted so completely that I'm sure he never said the government again without thinking about it, because Rod had made the point. And so this will be what we'll be sharing, and we want this, of course, we want everybody to help us get this to a much larger audience as we begin to put it together, because this will be something that we can share with those people who look at us like we're the nuts, because we're in there studying and we're trying to understand all of this and put it together. Some of this is going to be very, very easy for people to understand, and we can share it with those people who still remain skeptical or have their head in the sand. And it's really, you know, it's really coming together beautifully with all of the information that we've amassed over almost 2 years worth of effort here. So stay tuned.
Yeah, because ladies and gentlemen, like I said, there's a lot here to learn, but it's not as hard as what you think it is, because once you start understanding the basis of all this, this. And it's like I consider the guys that was here this weekend and other people I was talking to, stop and think, who and what is stopping you out on the street? Who and what is knocking on your door? Is this a private individual or is it a department or an agency employee? This is the key here. Who is the one that's knocking on your door? If it is an agency, then this makes it an administrative issue. If it is a department, again, this is an administrative issue. If it's your neighbor, then this is a civil or a private issue. But these people are all administrative part of the system. They're all employees. So therefore, anything that happens is administrative. So they are dragging us into the wrong courtroom. They have to bring us into an administrative court. This is one of the things that we were hammering on. It come out of Ohio. The judge made a comment that this is a constitutional court. It come under Ohio Constitution. Then good. Then that means you're not an administrative court, right? Therefore, administrative agency can't come in here. And you know what? Think about it. It has to be an administrative court. And this is what we're talking about with the Bar Association. The judges are coming back. Well, you have to have an attorney. Excuse me. What authority does an attorney have in this courtroom? Well, who's a member of the Bar Association, the Supreme Court? Excuse me. Show me where in the Constitution, in the federal Constitution, the state Constitution, where a Supreme Court can create a private association. Whenever the judges from the Supreme Court either had to be appointed by the president and agreed to by the Judiciary Committee on the federal side, or appointed by the governor and agreed to on the judiciary side of the state. How can anybody who being appointed can sit down and create something that they themselves could not have? Ladies and gentlemen, this is the argument. This is the issue here about the Bar Association. This is why when I was told about these amicus and curiae, this is why it went straight into Title 36, Chapter 705 for the Bar Association. It shows they cannot represent me. They can only represent the government. Any and all attorneys can only represent the government. And agencies, they can't represent you and I.
And that's exactly what that lawyer told you. In no uncertain terms, he came right back in there and said, we can't represent you. It was so clear that they had to represent the government. They weren't on your side. They sort of say they're going to write a brief on your behalf, but they're at the mercy of the court. So it's going to be interesting to see what comes out of that, because they were just, that point was made so beautifully. And this Trowbridge case, this IRS case out in Texas, how they used that 1040 to pretend to gain jurisdiction in that courtroom was a study in exactly how they are using the statutes and the territorial jurisdiction in order to pretend to have jurisdiction that they don't have. If you haven't read that case yet, go back and see how the judge, talk about a transcript that was interesting to read. That judge going back in and telling that lawyer what to do in order to obtain jurisdiction by filing in that 1040. And the argument that this man was able to put together after he studied and went back in and did exactly what Rod talks about, getting into their rules and their procedures and their definitions and getting down there until he understood how that income tax return was used to try to prove that he was a resident of the District of Columbia. Now that's a case to start reading too. You're going to learn a lot about how the courts act and how they obtain jurisdiction and, how they have done this against us in lots of ways.
Well, not only that, Rebecca, is from what Carl has done with the Stanley case in Oklahoma and Missouri, is that he walked into the United States District Court, asked the clerk of court, is this a tax court? And the first words out of their mouth, no, this is not a tax court. Ladies and gentlemen, that's an issue here. Now,
Yep.
one United States District Court is a tax court. They have to fly in a tax judge out of D.C., which now makes this an administrative issue. That now makes you the plaintiff in this courtroom. And they're not telling you this because the moment they fly in a tax judge, this becomes an administrative. You automatically become the plaintiff. It got switched. And they're not telling you this. This is the significance of understanding who is in that courtroom. What jurisdiction does this court have? Because, again, it's like we brought up about Ohio, and I brought it up here. You cannot charge me for a criminal charge for a driver's license issue. Whatever the Title 49 under CFR says, this is civil. No state can raise the ante when the federal government says it's civil. They can't raise it to a criminal level. And they have. Why? Because we're not coming back in and rebutting them on this. That's our issues, ladies and gentlemen. We have to know the jurisdiction of that court, and that court don't have it. So, like I said, education is where it's at. And I realize we got people on here who don't believe that, well, we don't have to learn anything. Isn't our job to know their rules? Then you live the way. But the point of it is, what we're doing here is we're exposing and we're laying out the fraud. And we're actually showing acts of treason on their side of this fence. And it has made them nervous enough to hire 3 attorneys that are interveners, especially whenever I had 50 of you came in on my case and filed third-party interveners and filed notice of corruption against the prosecution 50 different times. And I can guarantee you, these 3 attorneys probably going back in, my God, he's got 50 documentation of corruption against these people.
Well, I would also ask people who don't understand what we're doing here, how else would you do it? How would you expose the system? If you have a better way of doing it, let us know.
Yes.
Because we can't come up with a better way. It's the best way, in my opinion, is to have them exactly tell you, no, we're liars. No, we have no authority. No, we have no jurisdiction. And that's exactly what this is doing. These cases are doing. It's forcing these people to admit their fraud. It's a beautiful thing. How else would you do it?
Well, this is the whole thing. And I have offered, if you can find a better way of doing this, then show us how to do it. And this is exactly what and nobody's come up with any solution. You know, we got one guy said it's called using the law, and that's exactly what we used. We used the law. We used our own law against them because we went back and proved it can never apply to us through legislative statutes. We proved there's no way that could ever apply to us.
Yeah. That's a biggie. That's a real biggie. When you get that, absolutely. When you get that clear understanding, boy, that's a major milestone right there. When you really get that deep in your soul, then you're determined you're going to do something about it.
Well, that and the fact that, you know, you're walking in here, and that means IRS codes. They can't apply to us. But the main argument is when you pull out a Federal Reserve note and you ask the IRS agent, what is this? And you want it stated on the record of who created it, what was the intent, he's not going to say squat. And you look at the judge, says, look, you tell me what this is and what was the intent behind it. And then you sit here and explain to me how I'm supposed to pay taxes on something that you can't even discuss in this courtroom. That's the issue on the tax case. That's the issue with all these court cases. Well, you owe such and such a fine. Would you please tell me how I'm supposed to make a payment? Because pursuant to Title 18, Section 8, it's the obligation of the United States. And pursuant to Title 12, 411, it is the obligation of the United States. And the Federal Reserve Act of 1913, Section 16, obligation of the United States. I got 3 things here. It's not my job. It's yours. So explain, how am I supposed to, whenever it sits there and says, it's not my job, it's yours. Your laws, your rules, your intent, not mine. ladies and gentlemen, we're in a whole new section of teaching. It's no longer, and this is where I've watched people make mistakes. They walk in and they're challenging the court. Show me the law. Show me where it's at. That's no longer the case. And it's like Steve Herr come up with. It's no longer show me. I'm telling you where it's at, and why aren't you following it?
Yes.
Here's your law. Yep. Here it is in writing.
Yep.
These are your rules. This is how it's defined. Why aren't you following them?
Yep. And we understand it, and we know where you think you're getting your jurisdiction. Prove it.
Yes.
Because now we know the difference. And it's really not that complicated to understand. It feels it when you're really going through this, but as you sort of buckle down, and I've had people tell me that they spend hours listening to the radio shows, to the AIS shows, to the AIB shows, to others that are out there that are doing this teaching. They're doing the work that's required to begin to understand it. And that's all that anybody can ask of us, We just do our work one day at a time, and we do whatever's in front of us so that we can begin to understand and make a difference. The more of us who do this and really get it in our, just really get the understanding, it's going to make a large difference, because these people are not going to keep getting away with it like they have. And it's really up to us to do that. And, it really just it really just takes over as a labor of love to put all of this together so that you can help other people understand it. And that, that's what we all do. And we just appreciate, we appreciate your attention to these shows and your willingness to come out and learn with us as we're doing all of this. And it's, it's just what we all do. We thank you for that.
Well, yeah, because like I said, wasn't for you people out here and the donations that I've gotten. A lot of stuff, this paperwork, I've been there. I would have been no way I could afford to done the paperwork into DC. There'd been no way I could afford to make the trips into DC that I've made. Your donations have helped a lot. And now with what we're getting ready to do, I've got a new building out back. It's a 16 by 36. I've gotten some donations on it to help got it started and got it built. I'm working on the inside. Need more donations to work out with what we're doing, but this is going to be set up for a classroom. It's going to be set up so I'm not in the washroom with a washer and dryer behind me, and and the cabinets. We're going to have an office set up where we can actually come in and do better quality of audios and videos with what we're doing, because, ladies and gentlemen, it's education on our side, and it takes time on our side. And how many of you are willing to turn around and go donate hours and hours and hours and hours? I've had visitors have come here on Friday, it's here Saturday for almost 9 hours, Sunday for 9 hours, Monday for 9 hours. And it was basically all free gratis time. Now, if you had to go hire a lawyer at $250 an hour, you multiply that 250 times 9 hours a day, what would it cost you to go talk to an attorney?
Yeah. And what would you have gotten for that?
That's exactly right. So, ladies and gentlemen, what we're doing here is for your education. It is for your knowledge to be able to carry this stuff on. But it costs us money in order to get things prepared, in order to get things set up. But it's, like I said, it's your donations help with what we're doing here. And what we're talking about for this law school of setting it up for PhD school, ladies and gentlemen, we're not talking hundreds of thousands of dollars here for a 4-year education, like as if you were a lawyer. You're talking a very minimum of expense on your side of the fence. You know, they show these things on TV. For a pack of cigarettes a day, you can send money over to some Ethiopian child to feed 4 or 5 of them, or for a cup of coffee. Ladies and gentlemen, basically for what you're paying for a pack of cigarettes or a cup of coffee, the education level you're going to get is going to be better than any attorney out here.
Oh, yeah.
And it's going to be simplified for you to walk in. And once you learn the basis of this, there isn't any place at any time, anywhere, that you're not going to be able to use it. It doesn't matter whether you're talking city, whether you're talking county, whether you're talking state, whether you're talking federal government, whether you are in your state or somebody else's state or another state. It isn't going to make a difference. This stuff all works across the board. And this stuff technically actually works worldwide, because once you learn their job description, learn their rules, and know their language, this stuff will work worldwide.
And as you help yourself, then you begin helping your neighbors, your family, your friends. You know, you just naturally share. And so that's how we're passing along. And, you know, it's requiring us. I mean, you know, I wish you could see behind the scenes. You know, we're all having to learn so much of this stuff. We're having to do the webinar softwares and the Scriveners. We're putting together ebooks and the websites and the various things that we're doing. It does cost us, you know, to put all of this stuff together. So everybody, you know, does need to realize that it has been a labor of love. All of us have been just putting the work in and, you know, just persisting in getting it done so that we're getting ready to get it out there. So keep that in mind. We appreciate the donations.
Yeah, well, because see, a lot of what you guys don't realize, all right, it costs money for ink, paper,
yeah.
All right, but it costs you to ship it out. And if you need to get it out overnight, what does it cost you for an overnight package?
And the certified mail and everything else that goes along with it.
You know, all this is a necessity of what we're doing here. And then you got to sit down and figure the gas for your automobile, wear and tear. All this comes into play for expenses. Electricity here at the house, you know, and this doesn't include the time that you're spending with strangers instead of with family members. You know, so you're putting your family off to the side while you're working with strangers on their problems. You know, and this is all part of what we're doing here. And show me what attorney would sit here and work for you for 9 hours a day and put his family off to the side and not get anything out of it. This isn't about the money, but it is about, you know, your value, what you're doing has worth of what you're doing. You know, and it is nice to receive the donations for what you're doing, but there is a lot of stuff that we're handing out here, like documentation. We're not charging for documentation. You guys are getting this stuff free. One reason why is because it's got statutes and codes and rules and regulations in, and they are copyrighted. So therefore you can't charge for paperwork. But think about what your time would be worth of writing this stuff up and then sharing it out to all the people. Because Harvey said we got close to over 2,000 listeners on the website on this thing. Over 2,000 people that can turn around and take the paperwork for free, sit down and use it as a template for their own personal case. And we've got people on here that have, and they've won cases with my paperwork. Am I complaining? Absolutely not. That's why the paperwork is out there. It is to help you with what we're doing. It's to give you a floor mat of what you are to work with. It gives you a template. All you got to do is match your codes with your particular state, with what I have here for North Carolina. But ladies and gentlemen, like I said, with what we're doing here, it's all for you out here. It's not just for us, because I don't really have to do this. And I didn't have to go out here and put in a bigger shed out here for what we're using it for. I could have used something half the size and just kept it for the shed set. But that wasn't the purpose. We wanted education to keep going. We want knowledge to keep going. We want you guys to start understanding this, because the more of you that starts learning this, and we start hammering it, and we start walking in here, well, your rules here. Well, what rules are you talking about? Well, let's talk about under the rules of evidence under 402, 501, 802, and 902. Let's talk about your criminal rules. Where under Rule 4, your prosecutor here was supposed to file paperwork in within 30 days, and he didn't do it. Let's sit here and talk about, Rule 17, next friend. I'm allowed to come in here as next friend, but Section G says under any federal statutes. The private attorney general was declared under federal statutes. I can walk in here as a third party into this case. Ladies and gentlemen, you got so much here to play with. Education is unlimited. That's what you want to sit down and where you want to stop at and how far you want to run it. That's what this is all about. How far do you want to run it? And what are you willing to do for it? Ladies?
And I tell you what, those of you who are watching the video, you're seeing me sort of giggling in the background as Rod's talking about building this beautiful new office back there. We all teased him so much about doing his shows with in the laundry room in his pajamas that he had to do something about it. So, he's got his pajamas on tonight.
And don't forget,
we caught him at it again.
Don't forget the life-size poster of the washer and dryer in the bedroom, because it's not Rod Class without the washer and dryer in the bedroom. Okay, I can't.
Oh yes, we all have our fun, and we've all just got to know each other so well as we've worked together here that we can tease Rod about being in his pajamas, and then he shows that he is. Oh yes, it's serious stuff, but you got to have fun with it too. That's for sure.
Ladies and gentlemen, Harvey put up for donations. For those that's on a phone call, the address here is P.O. Box 435, High Shoals. That's HIGHSHOALS, High Shoals, North Carolina, 28077. And ladies and gentlemen, your donations helps promote what we're doing here. It helps, like I said, it helps send the paperwork out, because this last documents I sent out cost me $44. I sent them in by FedEx to the court system. Now, did I have to send them that way? No. But the thing of it is, I now know they was hand delivered to them, because I've ran paperwork through the post office, and I have pasted it now, because I do tracking on it. I have tracked it and tracked it and tracked it, and sometimes it's 3 weeks before it's posted when they received it. Now, that's the problem here. So by sending it out FedEx, I know it was all walked in and hand delivered to them. So we got a date. So I sent it out and on Tuesday, and they got it by Thursday. They got it Thursday morning at 9:30. So they were served. The attorneys were served. The prosecutor was served all this week. This is why, like I said, it does get expensive doing this stuff. But you're getting the blessings and you're getting the documentation of what we're doing and how we are going after them and exposing it. And that's the key here. But like I said, it does cost money. So, ladies and gentlemen, it's 11 o'clock here. I've been on here for 2 hours. If you two ladies got anything more to say, go ahead. Otherwise, we'll go ahead and close this thing up and we'll shut it down.
Well, I'm just going to tell everybody I love to hear from you. You can get in touch with me. It's easy to remember my email because it's operationspitwad@gmail.com. So if if you want to get in touch with me, if you have information, I love getting these court cases. People really send us a lot of information that's really helpful as we're putting all this together. One of the things I got today was a complete audit from an auditor who had done a foreclosure case. We get just really good stuff in. So, or if you just want to say, hey, Rebecca, and you've got something going on, just feel free to get in touch with me. operationspitwad@gmail.com. Sue?
I can't say it any better than you did. I'm here to record, and I'm here to enjoy, and I'm here to learn. So,
and we're gonna get our stuff back.
Yeah, we are.
Yes.
We're gonna get our stuff back.
Yep.
That's the goal. And we're gonna get everybody else's stuff back too. But you gotta help us.
Yep.
Okay.
Let's call it a night.
Appreciate it. We'll go ahead and sign off here with what we're doing. But ladies and gentlemen, I haven't been on here much. A lot of it because I'm sitting back and waiting to see what and how the court's going to handle this court case.
Yep.
Have got a lot of knowledge on here already of what we've done. And for me to go back in and start a whole new process of reiterating all this stuff all over again when it's already been recorded, it's time consuming on our side, but we are trying to get a better foundation of, like I said, we're trying to get the webinars up. We're trying to get a better class of education up because a lot of people have told me, Rod, we need hands-on. We need to see. And talk to you can't see anything. All you can do is hear. And people learn better. Some people learn from seeing. And hopefully with the webinars, we're going to be able to walk you through, give you the documents, let you walk through the documents with what we're doing, and work with you on this. And that's the key here, is to work with you on this. So I want to thank you all for being in here tonight. You all have a good night. And I'll be right back with you two as soon as I get off here.
All right. Good night, all.
Everybody.